I will start, my Lord, by reading out at paragraph 143 of the minority judgment. Just to put in perspective, they say in law, context is everything.
Yeah.
And at paragraph 143, my Lord, the judgment judges Teron J and Jafta J say the following about the main judgment.
Yes.
In my view, it is unconstitutional. In other words, they call that judgment unconstitutional to the extent that it violates sections 12 to 143, my Lord.
Yes, I have that. That's fine.
Okay, thank you, my Lord. In my view, it is unconstitutional to the extent that it violates sections 12 and 35(3) of the Constitution to order punitive committal for civil contempt in motion proceedings, where no remedial or coercive relief is granted.
Yes.
The main judgment, again and again, answers this concern with recourse to the exceptional facts of this case and the conduct of Mr. Zuma. In doing so, it fails or refuses to see the woods for the trees, with the result that in seeking to justify a punitive order which satisfies an understandable desire to address Mr. Zuma's scandalous disrespect for this court, it trammels over the constitutional rights of alleged contemnors, including Mr. Zuma. And I'm deliberately starting with that, my Lord, because it will be a theme of mine in this address that we should really take heed of that advice to see the woods for the trees. Now, what have we got here, my Lord? If we take away all the legalese and the terminology that might confuse the public, what we really have here, my Lord, is nothing other than an interdict before your Lordship.
Yes.
Pendente lite, and I'll come back to that. That's crucial. Effectively, to interdict or suspend the execution of a warrant of arrest. And I'm using that term loosely, deliberately, because as I say, if you take away all the peculiarities of this case, that is what we're dealing with. A warrant of arrest and committal. Arrest by the police and committal by the Minister of Correctional Services, effectively. So, as lawyers, we always talk about substance over form. So in substance, that really is what is in front of your Lordship. The court has had this to say about that situation. And your Lordship will find that in the case that we refer to in our heads, the Lordship will find that at paragraph 26 of our heads.
Yes.
The Lordship there. Thank you, my Lord.
Yes.
Yeah, it's the case of National Gambling Board versus Premier of KwaZulu-Natal, where the Constitutional Court said unanimously, the citation is at the bottom, my Lord, 2002, Volume 2, SA 715, Constitutional Court. And I'm going to read from paragraph 49 and 50. And I'm going to read it. Yes, just those two paragraphs. It says, the Constitutional Court said, in an application for an interim interdict, the dispute is whether applying the relevant legal requirements, the status quo should be preserved or restored pending the decision of the main dispute. I may pause there, Malak. That is why these orders are called status quo orders. An interim interdict pendente lite, it has been said, is to freeze, quote unquote, the status quo pending the main action. In this particular case, what is the status quo? The status quo is that the former president is not arrested, to put it colloquially, and is sitting at home and watching these proceedings. So the purpose of an interim interdict pendente lite is to freeze that status quo until the main action has been determined. In other words, until the Constitutional Court has finally determined the outcome of the main dispute. And then it says, at common law, I'm continuing with the quotation, a court's jurisdiction to entertain an application for an interim interdict depends on whether it has jurisdiction to preserve or restore the status quo. Let me pause again. Whether it, in other words, the High Court, has jurisdiction to restore or freeze the status quo, which is that the president who is within its jurisdiction is sitting at home. And here's the punchline. It does not depend on whether it has jurisdiction to decide the main dispute. It can never be clearer than that, right? It does not depend on whether this court has the jurisdiction to decide the main dispute. In other words, the rescission application. It does not. Contrary to what you've been told and what is being bandied about in the media by experts, so-called. It does not depend on whether the court has jurisdiction to decide. And here it goes, my lord, on paragraph 50. Whether a high court will have jurisdiction to grant interim relief pending a matter exclusively within this court's jurisdiction, in other words, the Constitutional Court, does not depend on the form or effect of the interim relief. And I read that again. Whether a court will have jurisdiction to grant interim relief pending a matter exclusively within this court's jurisdiction does not depend on the form or effect of the interim relief. It depends on the proper interpretation of the relevant provision and on the substance of the order, right? So what is the substance of the order here? We've already said section 172 and the common law order and the part B consideration. And it said, does it involve a final determination of the rights of the parties, or does it affect such a final determination? If it does not, as it clearly does not here, the High Court will, depending on the provision that grants exclusive jurisdiction, have jurisdiction to grant interim relief. Right? In other words, your lordship would have jurisdiction even in a situation where the main relief was within the exclusive jurisdiction of the of the Constitutional Court. So, if, my Lord, that is so, then with the greatest, and remember, my Lord, we're dealing here, in fact, this is a classical situation that applies that a fortiori rule.
Yes,
I'm sorry, my Lord.
yes.
Now, I'm saying, my Lord, that remember, this is a situation where actually contrast that with the situation of exclusive jurisdiction. What we have here is the exact opposite. Rule 42, as your Lordship knows, actually is a rule of the High Court. It comes from the Uniform Rules of Court. It just so happens that the Constitutional Court borrowed the rule by the expediency of Rule 29 of the Constitutional Court rules. So far from being a situation where there could be any talk of exclusive jurisdiction by the High Court, we have here a situation where the main application is actually being determined according to the rules of your Lordship's Court, which is the High Court. So how can it be then argued, my Lord, that your Lordship does not have jurisdiction to grant interim relief pending a matter which is not even within the exclusive jurisdiction of the Constitutional Court? Then, my Lord, as far as if there's any need still to give your Lordship the sixth basis, the Lordship, I'll refer your Lordship, and I won't develop this point much further, to Rule 45A of your Lordship's, of the Uniform Rules of Court. And the importance of this, we might as well make it half a dozen reasons. Rule 45A says the following, my Lord. The court, meaning the High Court, may, on application, suspend the operation and execution of any order for such period as it may deem fit, provided that in the case of appeal, such suspension is in compliance with Section 18 of the Act. And I'll explain to your Lordship why that is so important. Now, here's the importance of that, my Lord. And this goes back to really to the philosophical foundations of this whole suspension story, as your Lordship knows, is based really on the following constitutional proposition, which underpins Section 18 of the Superior Courts Act. It would be unjust, for obvious reasons, that if you appeal, and I know this is not an appeal, and I'll explain the connection, my Lord. The connection is the one made. The Section 18, as your Lordship knows, applies to appeals. But forget the nitty-gritties. Let's look at what is the philosophical foundation. The philosophical foundation is that if you appeal, or rather, if you, let me put it in a neutral fashion, if you have other proceedings whose aim is to set aside the order, whether it will be set aside as a result of an appeal or a rescission order, for the purposes of this discussion, is neither here nor there. the Lordship knows that one of the orders that we seek in the Constitutional Court's notice of motion is the setting aside. I think it's order number, it's JZ2, my lord. If your Lordship doesn't have paginated papers.
What page?
On the paginated papers, it's page 39. It's the, your Lordship will remember there are just two annexures to the, your Lordship. Prayer 2, my lord.
2, okay.
I mean prayer 3, I'm sorry.
Yes.
The Lordship will know that one of the orders we seek is for paragraphs 3, 4, and 5, and 6 of the order of the court to be set aside. Right? Following on the rescission. What I'm trying to say, my lord, is that I'm jumping the reason for the setting aside deliberately. So I'm saying whether the setting aside is going to happen as a result of an appeal or a rescission for the purposes of this argument is not relevant. The foundational philosophy is that if there is a threat that the order may be set aside, then the execution of that order in the case of an appeal is automatically suspended automatically in terms of section 18. So the only difference is that that situation is regulated by statute. So it's automatic.
With the appeals as well.
Well, my lord, I'm explaining that that distinction is irrelevant for the purposes of it deals with the setting an order that is likely to be set aside. And whether it will be set aside as a result of an appeal or a rescission for the purposes of this argument is irrelevant. Quite correct. As far as it deals with appeals, until 2010, that situation was like the situation you have here, determined by the common law. So it really doesn't matter that it just so happens that in that case, the statute, the legislature saw it fit to codify the common law. But what I'm trying to say to your lordship is that the common law foundations of not executing an order that is liable to be set aside remain intact. And that is why Rule 45, in a way, specifies that the Section 18 situation is catered for by Section 18. But Rule 45, therefore, caters for other situations, such as the one in front of your lordship, not the one that is catered for in Section 18. And therefore, this court, there can be no doubt on that basis as well that apart from Section 18 orders or appeal situations or application for leave to appeal, this court has jurisdiction as well based on Section 45 to suspend any order. So I hope then, my lord, with those 6 reasons, it covers the full ground of the jurisdiction for over any order, jurisdiction for an order of another court, jurisdiction over a court of where there it might even lie exclusively in the Constitutional Court. In that matrix, my lord, there is no room whatsoever for this argument that your lordship does not have jurisdiction over the main action. And I'm saying, my lord, even in the unlikely event that your Lordship did not have jurisdiction simply because this is a rescission and not an appeal. And your Lordship knows, by the way, from the case of Tasima, that it has been said that Section 18 applies to appeals that go right up to the Constitutional Court. So, a fortiori, again, the suspension would apply to those situations as well. But so that's reason number 7. So even if your Lordship was somehow right that Section 12(1)(b) of the Constitution thankfully outlawed detention without trial, so that those of us who were victims to it can rest with thought after 1994.
Yes. But I think those issues really will be ventilated in the Constitutional Court, I think.
Aha. That is exact. Then your Lordship and I, yes. Then your Lordship and I we're on the same page. All I'm saying, my Lord, is that the invitation for your Lordship to reach those issues is improper. So I agree with your Lordship.
Yeah.
Not only because the main application covers the most fundamental. I have never seen a situation where the judges of the Constitutional Court say that this judgment is unconstitutional. That's a very, very sobering statement, my Lord. Because what it means is this. The court, remember, there's a misapprehension which people might have, that what is actually supreme is the Constitutional Court or any court. Well, that is not true. What is supreme is the Constitution. And no institution, including a court, including a president, including anybody, because thank God we don't live in a monarchy where there's a so-called prerogative. So there's no institution in this country that has the right to exceed its powers and breach the Constitution or act unconstitutionally, even the court. And if it is true, my Lord, it's a big if. If it is true, and if there's even a possibility that in the rescission application, it will be found that the majority acted unconstitutionally and breached the Section 12 rights of detention without trial rights of the accused person or the appellant, as far as the hybrid situation is concerned, or even the 35(3) rights, or any rights, the rights to dignity, the rights to equal treatment, all the rights that we have invoked. If that is a possibility, and it must be a possibility, my Lord, because no less than the Constitutional Court of this country has done what is another extraordinary feat, and I'm sure my learned friends will agree, that it is only in a few cases where the Constitutional Court has done what it has done in this case, which was to issue directions for a hearing of a matter literally within 24 hours of the lodgement of the papers. And as I say, it's usually done in those electoral matters where the election is tomorrow and so on and so on. But it's one of the rarest things ever to be witnessed. Thank you, my Lord. And your Lordship will know that those of us who practice in that court at least will know that that is a rare occurrence. To make it worse, my Lord, for those 24-hour instant directions to be granted on a Saturday, In other words, the court could not even wait. We submitted our papers in the late afternoon on Friday. And those were not, by the way, urgent papers. And the urgent application is the one before your lordship. But the court, in its wisdom, decided that it could not even wait until Monday to issue those directions. And your lordship, once again, must read between the lines with respect. Your lordship must read between the lines of why the police, the National Commissioner, Minister of Justice, the President have not opposed this matter and are quite happy that your lordship should grant the relief that is sought, and why the Constitutional Court gave urgent directions on a Saturday, which were not asked for by anybody. And if your lordship, despite all that, can read that no, and despite, let's go back to our assumption, assuming that the matter is unopposed, as I respectfully submit, your lordship can say, well, on all those circumstances, the fact that we're dealing with the possible arrest of a 79-year-old person whose health condition is uncontestedly precarious, to say the least, who is not a flight risk, who, when the rescission application is all finished, if he is unsuccessful, will duly face the consequences of that lack of success. In all those circumstances, then why on earth, my lord, would anyone say that there is any, even if you look at the balance of convenience test or any other test that your lordship has under the common law, what is the harm that these respondents will suffer if the order is suspended, as opposed to any harm? I'm sorry, my lord.
So, on the seat of the directions from the Constitutional Court, did you consider to, approaching the Constitutional Court and ask to stay the execution of their order?
No, my lord. You can't do that. That is why, my lord.
Why?
Because
yes, carry on. Yes.
No. Let me get your lordship's full question.
Yes, I'm saying once you received the directions saying that your matter will be dealt with on the 12th of July, did you consider approaching the Constitutional Court and say to them, look, now that you have given us a date for the 12th of July, can you then consider staying the execution of your order until that date, the 12th of July?
Well, my lord, let me put it like this. Your lordship will see from the factual matrix that the applicant, former President Jacob Zuma, one of the things that brings him to this situation, by the way, is the fact that he says that he is unable to fund litigation which is unnecessary. That's what got him into the soup in the first place. Because, as your lordship knows, he was of the view that because the prospects of the urgent direct access application in the Constitutional Court, according to his advice, which I would have given myself, and I think any reasonable lawyer would have given, the prospects of the Constitutional Court of this country hearing a matter like that on an urgent basis and on a direct access basis, given the matters that they have rejected, which are more meritorious, were slim, let's put it like that. And it was for that reason that and with hindsight, of course, Your Lordship knows that that turned out to be wrong. But we must place our mind at the position that he was in December before the order was granted. That was one of the reasons why he did not oppose that application. And I can assure you that might even be one of the reasons why those people are not opposing the application before Your Lordship, because it's a usual reason. This day and age, litigation is expensive. So you don't just engage in litigation just for the sake of the textbooks or theoretical reasons. So why would the former president, my lord, when he has lodged an application in this court,
yes,
obviously, and Your Lordship, again, hindsight, as they say, everyone is clever after hindsight. Remember, on Friday, Your Lordship, the applicant did not know that the Constitutional Court was going to issue directions on Saturday, right? So we must always put ourselves in the shoes of the person. So on Friday...
But normally, when you want to stay the execution of an order, especially in a rescission application, that forms part of the application that you make to that particular court and ask it, please don't execute your order pending the outcome of the decision application. That's what you normally do. Yes.
Yes, well, then that's a different question, my lord. I thought Your Lordship was saying once the directions were issued. Well, let's answer yes. the different question. The first question I've answered, as I said, once the directions were issued, it already he had a pending action. And it would have been foolhardy and wasteful for him to say, oh, well, now I'm going to withdraw the other application. And so
I understand, yes.
Yes. But the answer to the second question, which is a different matter altogether, is the following. It goes back to what we said about the Gaba, Chirwa, and those kinds of cases. Our law is very clear, my lord. If there are two courts that both have concurrent jurisdiction over a matter, then that's the classical example of concurrent jurisdiction. Then you don't ask that question. Why did you not go to the other court? And that's where we started this morning. You only ask, does this court have jurisdiction? And if the answer to that question is yes, the mere fact that there may be another court that has equally concurrent jurisdiction is mightily irrelevant, because it is the election for whatever purpose of an applicant, for example, in a labor matter, who has been unlawfully terminated. Once they make an election and say, I'm going to go to the labor court, then they must stay with that election. But if they make the election to say, I'm going to go to the high court, you can't say, but you should have gone to the, it's a secular argument, you should have gone to the labor court. Because they'll say, yes, I know I could have gone to the labor court, but I came here. So the only question is, do you have jurisdiction? You can't kick him out on the basis that he could have also gone to the labor court. That would be exactly what the Constitutional Court in Kaba said you cannot do. Because you must look at the pleadings of that particular case, and not whether he could have gone to the water court or the land court. That may well be so, but the question is the wrong question to pose. And you might even say, oh, well, it might be cheaper in the labor court, or it would have been set down quicker than in the high court. Well, so what? The litigant would have elected to come to a court that also has jurisdiction. So that question, with the greatest respect, does not arise in the earlier situation. Besides, my lord, it goes back to what one might call prudence or the economics of litigation. Imagine, my lord, if even the richest litigant in the world, if they were to say, okay, I've got this Part B, which is exclusively in the jurisdiction of the Pieter Maritzburg High Court. I also have an interim interdict, which in terms of section 172, is within the jurisdiction of the Pieter Maritzburg court. And I also have a third cause of action, which is in the jurisdiction of the Pieter Maritzburg court, but also in the jurisdiction of the Constitutional Court. So, but now I'm going to bring two actions, one in the Constitutional Court and another one in Pieter Maritzburg. That would be a foolhardy way of litigating, because it goes back to what we call the once and for all rule. It would, even in those circumstances, be open to that litigant to say, well, I already have these two causes of action over which the Pieter Maritzburg High Court has jurisdiction, and therefore, even this third one, even if, as I indicated from the gambling board case, even if that third cause of action was lied in the exclusive jurisdiction of the Constitutional Court, this court would have, under Section 173, jurisdiction to regulate, to say, well, this situation is not foreseen by the rules, but clearly, are we really going to send one litigant to two separate courts for the same thing? So I'm afraid that question, with the greatest respect, my lord, does not arise at all. If it does, it really would be forcing an applicant to litigate in two different places, or three, for example. Let's assume the third cause of action lied in the Land Act. Then he would have had to issue in the Maritzburg High Court for Part B, an issue in the Land Act for the other part, an issue in the Constitutional Court for Part C, let's say, quote unquote. And that, by the way, my lord, is how your lordship should look at this. Conceptually, look at the rescission application as, let's call it Part C. So your lordship has got Part A in front of you, and this litigant has got Part B, over which your lordship has jurisdiction, and then Part C, over which your lordship has concurrent jurisdiction. Then what's wrong if the litigant brings it to you? Imagine the opposite, my lord. Imagine if he had said, okay, no, I'm actually going to go to the Constitutional Court and raise the issue of the suspension of the order there. And somewhere, because I'm already there, I'm also going to raise the unconstitutionality of the Criminal Procedure Act. Then he would be laughed out of court, because the Constitutional Court would say, yes, we know that we have concurrent jurisdiction over the rescission application, but why on earth are you here for your Part B? Because you know that only the High Court has primary exclusive jurisdiction over that. So that would not work either. So the only option then he would have, my lord, is not a place where he could have brought both of his actions together. The only option is the absurdity of having to bring them in two separate places when one of those places has got jurisdiction over both, which is your lordship's court. That would be not just imprudent, but absurd. So my lord, we just got back to this, but I was actually dealing with the merits, yeah. And I appreciate your lordship's opportunity to address that, because that's a valid question as to how the choice is made at a particular point. Firstly, I'm saying one must put yourself into where he was on Friday, and secondly, put yourself into where he was on Saturday, once the directions of the Constitutional Court were issued, where he would have had, if one followed your lordship's that advice, he would have had to then withdraw a portion of what is before your lordship and bring it in another place and still come here on Tuesday. And I mean, that's just unwieldy and unworkable and unadvisable, ill-advisable. But the only point I was making, my lord, on the merits was that your lordship, with the greatest respect, cannot second guess the outcome of the rescission application itself. And your Lordship has already said that. And I therefore won't go into your Lordship about the Section 12, the detention without trial, and all those issues. Because those are the issues that the Constitutional Court, in its wisdom, at the very least, your Lordship owes the Constitutional Court that to defer, that deference to it. I know that the directions of the Constitutional Court cannot be elevated into a court order. We don't make that absurd proposition. But it is there, my Lord. We say in our heads, the fact that it is there at the same time cannot be ignored as if it does not exist. So your Lordship must give it some legal effect, not as much legal effect as if it were a court order, obviously, but not zero legal effect as if it did not exist. Because it is there. It cannot be wished away. And it must say something. It must, at the minimum, say this, that the Constitutional Court of this country, 11 judges, feel that the rescission application is something that is worth to be listened to. And that on the basis of that listening to, if we take the rules aude alteram partem to its logical conclusion, it cannot be that any court says, I will listen to you, but I know that I'm going to find against you. If that is the basis on which those directions are issued, then they would be illegal. Surely, those directions are issued on the basis that this matter is worth hearing and there is a possibility that you may succeed. Otherwise, speaking for myself, I'm not going there. If the idea is just to give a hollow hearing from which there's no possibility of success. And I'm 100% sure, as your Lordship would be, that our Constitutional Court would not make such a wasteful exercise and issue directions which would be a waste of paper in that manner. So, if we therefore accept that whatever legal effect the directions have and their existence is something that your Lordship must take into account, the fact that before your Lordship and before the Constitutional Court, the state parties, let me call them that, are abiding by the, you'll see from the letter that they say they will abide even in the Constitutional Court alone. Is there, it's a fact that your Lordship must take into account. But more importantly, my Lord, sorry, I thought the Lordship looks like he was going to ask me a question. Yeah. No. Can I just finish that thought? Yes, my Lord. Yeah. Sorry, my Lord. These electronic things are so prone to interruption. No, but yes. The fact that the order, or rather the Constitutional Court may find in favor of an applicant in situations where we're dealing with the liberty of a person, my Lord. This is not about whether the car is going to remain with me or my learned friend, Mr. Ngokai Toby, or that kind of thing. This is about the liberty of an individual in a democratic constitutional state. And that is why when we say this situation is akin to habeas corpus, we don't say it lightly, my Lord. It is exactly the same situation as when you do an application for habeas corpus when the person has already been arrested. And you say, you can come to court, your Lordship knows it happened under the sun. Maybe in some regimes which don't have constitutions, it happens all the time. Never. And that person, my Lord, who's subjected to that, where the order, the person who originates the order that your Lordship is talking about, says that this is unprecedented. I could not find it anywhere. It's happening for the first time. In a court of last instance, my lord, of first and last instance, where the right of appeal has been denied. No, my lord. With the greatest respect, if anybody under those circumstances can say that such a person must, while waiting for that extraordinary order to be set aside, be sitting in jail to satisfy what? The vengeance and the hatred or whatever animosity might be that might emanate from these respondents, the commission, the acting Chief Justice, and the what's it called? Helen Suzman Foundation, probably with an office somewhere and a laptop. So when my lord, and hear me out, my lord, here, just on this, if nothing else. And this goes back to your lordship's favorite topic of jurisdiction and introduces another arrow to that bow. Remember, my lord, that in this case, unlike your lordship will remember, there's a case called Saratoga Avenue. Sorry, my lord. Yes. Occupiers of Saratoga Avenue versus City of Johannesburg Metropolitan Municipality and another, which is 2012, volume 9, BCLR 951 CC. Oh, sorry, my lord. This is difficult to manage these kinds of hearings. It was said, okay, let me again start by telling your lordship where I'm going with this, so that as I develop it. There are situations, my lord, where the Constitutional Court arrogates to itself the execution of an order. The lordship knows that. Where it would, when it grants an order in these kinds of situations where evictions and so on, the Constitutional Court appoints itself, so to speak, as the supervisor of an order. Those situations must be contrasted to situations where the Constitutional Court has deliberately and expressly delegated the execution of the order to another agency. Don't know if your lordship
is with me.
That distinction. Yes. Now, what do we have here in front of your lordship? We have, if your lordship goes to the actual order, that brings us in front of your lordship. And the lordship will find it, the convenient part is just the beginning of the judgment, where the order is set out, yes. Paragraph, order number 5. Well, let's start with number 4. That's the arrest, the sentence. Mr. Jacob Zuma is sentenced to undergo 50 months imprisonment. Then number 5 says, very important, my lord. Mr. Jacob Zuma is ordered to submit himself to the South African Police Service at Nkandla Police Station within your Lordship's jurisdiction, or Johannesburg Central Police Station, within, again, the order of the issue of concurrent jurisdiction arises. In other words, we could have brought this in front of your Lordship. We could have also have brought it in the Johannesburg High Court. But if we went there, nobody would have said, why did you not go to Maritzburg, as I've said earlier? Or nobody could justifiably say that. Anyway, it says, within 5 calendar days from the date of this order, for the station commander of the Nkandla police station or other officer in charge of that police station to ensure that he is immediately delivered to a correctional center to commence serving the sentence imposed in paragraph 4. Number 6, in the event that Mr. Jacob Zuma does not submit himself to the South African Police Service, not to the Constitutional Court, as required by paragraph 5, the Minister of Police and the National Commissioner of the South African Police Service must, within 3 days, calendar days of the expiry of that period stipulated, take all steps that are necessary and permissible in law to ensure that Mr. Jacob Zuma is delivered to a correctional center in order to commence serving the sentence imposed in paragraph 4. What does that mean? It means that in this particular instance, the Constitutional Court deliberately, when it had the power to assume the supervisory and execution powers of the order, delegated those powers to the Minister of Police and the National Commissioner. This Constitutional Court of this country, my Lord, knew that the people that it had enlisted here were, before it, the second and third respondents. And that there was somebody else called the Judicial Commission of Inquiry and another somebody else called the Helen Suzman Foundation. It did not delegate to them the power to arrest and detain the former president. Why? Because the institutions that are constitutionally empowered and charged with that responsibility are those to which it indeed did delegate. And those institutions, my Lord, are before you. So the execution of the order is in the hands of those people, including the station commander of the Nkandla police station. And those people are rightfully before your Lordship. Now, why is that important, my Lord? It is important because in the Saratoga case, sorry, my Lord. That distinction was made by Froneman J. at paragraph 12 onwards. So the Constitutional Court said, it is important to remember, however, that the kind of orders on let's start at paragraph 11, my Lord. It says, when a court decides a constitutional matter within its power, Section 172(1)(b) of the Constitution allows it to make any order that is just and equitable. I've already addressed that proposition. I'm just quoting that part for emphasis. And then it says, it is important to remember, however, the kind of orders sought to be varied in Zondi and discharged in the residence of Joe Slovo community. These were other cases. In Zondi, a statute had been declared constitutionally invalid, and under the just and equitable remedy provisions of Section 172(1)B, this court had suspended order of invalidity. In residence of Joe Slovo community, the eviction order made by this court was, quote, coupled with a detailed supervisory order concerning the execution of that order. These were both cases where this court made just and equitable orders that made it clear that the court itself, in other words, the Constitutional Court, chose to regulate and oversee their execution. Unlike the court that is the case that is before you. That is not the case here. That is now paragraph 13. Just as it is not before your lordship. That is not the case here, and will really be in appeals heard by this court. There is no indication in Blue Moonlight 1 order of any continued oversight by this court. In the absence, this is the punchline, in the absence of a clear indication of this kind, it must be accepted that the order this court makes on appeal becomes the order of the court of first instance, in other words, the High Court. Now, what does that say, my lord? The importance of this, and I know the facts are different, but I'm saying the Constitutional Court made a distinction between those orders which would be supervised by it, which it makes when it wants to, and those orders that must be supervised by other people, which it makes when it wants to. And your lordship is dealing here with that, second type. And for that additional reason, if your lordship just reads the order as it is, which assigns all these people, these players, including the station commander, within the area of jurisdiction of this court, the power to actually effect the actual arrest and or the committal. Because your lordship would know, we all know from experience, that if the station commander of Ganza were to effect the arrest, then of course he would then be committing the person to a correctional service center that is within their own jurisdiction, which again falls into your lordship's jurisdiction. Putting aside the fact that members of the security cluster, such as the Minister of Police, the National Commissioner, and to some extent the President, have found it necessary that the arrest should be put in abeyance. Putting it aside, that, my lord, and this is an important point, on the experience of this particular case, the urgent relief which was sought in February was only granted in July, end of June, 29th of June, 3 months thereafter. So what your lordship is being asked, and I'm not saying that the next judgment will be 3 months, it might be 2 months or whatever it is. Let's even say 1 month. But what your lordship is being asked to do is that for all that period, between now and the hearing, between the hearing and the judgment, 1 month, 2 months, 3 months down the line, the applicant must be sitting in jail without ever having seen any trial. And then only thereafter, if the judgment is set aside, say, oops, then he must be released. What is that, my lord? What is that? And it goes, my lord, to the root, with the greatest respect, my lord, of what I called at the beginning of this address, the nature of the relief that is sought before your lordship. And I'll refer your lordship without going there directly to my lord, that is paraphrased the D6-4 of Erasmus as follows. An interlocutory interdict is one which is granted pendente lite. It is a provisional order designed to protect the rights of the complainant party pending an action or application to be brought by him to establish the respective rights of the parties. It does not involve a final determination of the rights of the parties and does not affect such determination. Underline that. It does not involve a final determination of the rights of the parties and does not affect such determination. Its effect is to freeze, quote unquote, the position until the court decides where the rights lie, at which point it ceases to operate. It is aimed at ensuring, as far as it is reasonably possible, that the party who is ultimately successful will receive adequate and effective relief. Right? The party who is ultimately successful. In other words, put yourself, with due respect, my lord, in the shoes of this applicant when he is ultimately successful in the rescission application. And ask yourself, my lord, whether he will have received effective and adequate relief if 2 months, 3 months down the line, he would have been sitting in a prison cell. The answer is an obvious no. And that is the nature of the proceedings before your lordship. And that, with the greatest respect, should compel your lordship to find that in this particular matter, based on just and equitable remedy, based on anything, quite frankly, based on just the interests of justice, based on the public interest considerations which must have been taken into account by the non-opposing respondents, based on justice and the operation of the laws on Section 172 and the interim interdicts pendente lite, and based on simple justice, my lord, your lordship has to grant the order asked for, if nothing else, on the basis that Part B before your lordship falls within the exclusive jurisdiction of your lordship, and Part A may or may not fall within the concurrent jurisdiction of your lordship and any other court, which I've said is irrelevant. But more importantly, the fact that that other court happens to be the constitutional court does not change the rule set out in Pollack and in the relevant cases, that this court has jurisdiction in respect of the execution of any other court. If that was so, then the judgment in gambling board, which says that even when the main action falls within the exclusive jurisdiction of the constitutional court, this court would have jurisdiction, would be wrong. And it is not wrong. Well, my lord, that will be the longest unopposed application the lordship has ever had to entertain. But if there's anything else I want to unless if the lordship has a question, of course.
I don't have. Or should we take a short adjournment?
Yes, we are now at 2:30. I feel for everyone who's been sitting through these 2.5 hours. Perhaps we should take an adjournment. I just don't know what would be effective.
About 30 minutes. Is it okay?
30 minutes.
Yeah. If it is okay.
I can't. Can I just outline, my lord, what I'm going to do? And
No,
then
I'm just saying. I'm just